Good afternoon, everyone, and welcome to the OCBA Business Law Committee's first CLE of the year, Navigating COVID-19 Landlord Tenant Issues. I have the honor and privilege of introducing our four speakers this afternoon, starting with Ronny Edwards. Ronny is a shareholder at Lowndes and a member of its litigation practice group. Ronny practices throughout the state of Florida, both at the trial and appellate levels. Ronny focuses primarily on complex business, banking, contract, and real property litigation. He regularly represents national and state banks, title insurance companies, developers, commercial landlords, business owners, franchisors, and franchisees. And Ronny is also the immediate past chair of the OCBA Business Law Committee. Next, we have Tim Miedona. Tim Miedona is a shareholder at Lowndes and the co-chair of its commercial leasing group. Tim's practice focuses on commercial leasing, real estate transactions, development and finance, and corporate securities. Tim routinely represents commercial landlords and tenants in the negotiation of their commercial leases and in commercial lease workouts. Next, we have Mike Provenzale, who is a shareholder at Lowndes and a member of its creditor rights practice group, representing institutional and private lenders in commercial loan foreclosure and other collection lawsuits, receiverships, workouts, bankruptcies, and REO dispositions throughout the state. Mike's litigation practice also includes business, real estate, and condominium litigation. Additionally, Mike has experience in the area of real estate transactions, development, and finance, where he has represented a myriad of private and public clients in connection with the leasing, financing, acquisitions, and disposition of commercial real estate. Finally, Jamie Walson is a shareholder at Lowndes and represents title insurance companies, commercial landlords, property owners, buyers, and lenders throughout Florida in both transactional and litigation real estate matters. Jamie has negotiated commercial leases, purchases, and sale agreements for rental space, office buildings, and medical offices. Jamie has also litigated matters involving contracts, title insurance liability, commercial landlord-tenant matters, easements, fraud, deed warranties, boundary disputes, adverse possession, lien priority, and access rights, including conducting appeals both before the Florida 2nd and 5th District Court of Appeals. Also, anecdotally, I have the honor of working with all four of these attorneys, and I can say that they're great people and highly sophisticated attorneys. So with that, let's turn it over to the speakers. I'm going to try to pull up this PowerPoint presentation now. And also, before we start, if you all have questions during the course of the presentation, please go ahead and type them into the group chat. And at the end, I'll read them to the speakers to answer at the end of the presentation.
All right, good afternoon, everybody. I'm Jamie Walson from Lowndes. And Michael, thank you for the introduction. We probably would have made your life easier if we'd had you reading, disclaimers for dangerous medications. We gave you enough words to say, right? Today, I want to talk about, or the four of us are going to speak about four topics. We're going to start off, I'm going to discuss the current status of Florida courts concerning landlord-tenant disputes. And all of our presentations will be focused on commercial leases, not residential. Lease workout considerations, forbearance and abatement agreements, lease avoidance issues, which we'll talk about force majeure and possibility of performance and frustration of purpose, and then creditor and lender concerns, including the nuclear option of bankruptcy. So next slide. So now let's talk about commercial evictions and how they've been impacted by the various emergency orders around the state of Florida, and then also the current status or a brief overview of the commercial eviction process, which we can use as a backdrop for some of the discussion later today. There's typically four phases, and we'll talk about it in a little more detail, but sending a demand letter, giving the tenant an opportunity to cure, filing an eviction lawsuit, the tenants filing an answer and depositing of rent into the registry of court, and then the entry of a final judgment of eviction and the service of a writ of possession. Next slide. So contrary to what you may hear on occasion from your clients or others, there is currently no eviction moratorium, certainly on commercial matters in the state of Florida. Governor DeSantis originally entered Executive Order 20-94, but that, by its language, only applied to residential evictions. There were some circuits around the state of Florida that broadly interpreted it and applied it to commercial evictions as well. But as the executive orders were amended over time, it became clearer and clearer that they only applied to residential evictions. The most recent executive order, 20-180, only created a potential defense for residential tenants, and that has also expired. And again, that's only on the residential side. So there are currently no emergency orders impacting commercial evictions in Florida. Next slide. Similarly, the Supreme Court of Florida earlier had entered an administrative order which suspended the issuance of all writs of possession, be it residential or commercial. And that order has also expired, so it's full steam ahead in terms of commercial evictions. Next slide. And finally, there are no local court orders that I'm aware of that are still in place. There were early on during this crisis, various local court orders suspending real property actions, declaring evictions to be non-essential cases that could not be filed, but those have expired in large part, and certainly in Central Florida, evictions are a go. So with that in mind, let's talk about the eviction process in Florida. Next slide. So your 99% of monetary default commercial evictions are going to start with a notice. This notice is sent both pursuant to the lease requirements as well as Section 83.20 Florida statutes, which requires that a demand be made for the payment of rent or possession of the premises. This demand has a statutory form that the courts have strictly construed. Now, the demand letter can be waived by the tenant in the lease, but that waiver has to be express. And so typically what you'll see is the notice is sent. If the tenant fails to pay or makes a partial payment, then you can proceed with the filing of the eviction lawsuit. Next slide. The commercial eviction lawsuit, you have two choices as the plaintiff. You can file it in county court if you are only seeking possession, or you can combine it into a multi-count complaint. And if the amount of rent that is due or the accelerated rent exceeds the circuit court jurisdictional amount, then you can bring it in circuit court. You can also file separate actions, so one in county court, one in circuit court. And the advantage of, frankly, of filing these actions in county court is that the county court judges, a large part of their daily routine on the civil side is dealing with evictions, both residential and commercial. So as a result, our county court judges are very familiar with Chapter 83. They're very familiar with the process and the various remedies, and frankly, the expedited nature of commercial evictions. And so typically, I will file them in county court because I know that the county court judges are able to expedite them on their calendar and give priority claims to commercial evictions. Next slide. So a commercial eviction in Florida, in and of itself, operates on an expedited process. They're governed by Section 51.011 Florida statutes, which is the summary proceeding statute. It is a 5 business day summons. The summons can be served via posting at the property as long as 2 attempts at prior service have occurred. And then on that 5th business day after service, an answer must be filed by the tenant. The statute's very clear that motion practice is not permitted, that any discovery is only with leave of court, and it doesn't postpone the trial unless good cause is shown. And so, in fact, there are cases where tenants have filed motions to dismiss to a county court eviction lawsuit, and the appellate courts have said, we're going to treat the motion to dismiss as the defendant's answer for purposes of 83.21 and 51.011 Florida statutes. Next slide. The biggest tool in the arsenal of a commercial landlord is 83.232 Florida statutes. This is a provision that provides that in monetary default cases, the tenant must pay the rent into the registry on or before the date the answer is due, unless the tenant raises the defense of satisfaction or contests the amount that is due. And so if the amount is contested, then the next step is to have an evidentiary hearing, but that hearing is very, very limited. The court can only focus on, or by statute, is to only focus on two issues. One, has the tenant been properly credited for the payment of rent? And two, what properly constitutes rent under the lease? And so with regard to the definition of rent, a well-drafted commercial lease will always have a catch-all provision in the state of Florida that says something to the effect of all sums due hereunder, whether or not categorized as such, shall be considered rent or additional rent. And that way, when you get to this rent determination hearing, you point that clause out, and that knocks one issue out of the hearing altogether. Secondly, on the issue of the properly crediting, there are cases in Florida that strictly construe the statute and say that even the filing of a counterclaim by a defendant tenant asserting that is entitled to funds does not create, the court is not to take that defense into account for purposes of the rent determination hearing. It's strictly an accounting issue. Has the tenant paid the rent that's due under the lease? And so I have yet to have a judge post-COVID assert that via frustration of purpose or impossibility or force majeure or other equitable concerns that the tenant's rental obligations result in a credit for purposes of this hearing. Rather, what the courts, and I think appropriately so, have been saying is, hey, the lease says rent is due on this date, it's in this amount, you pay it, and then we'll figure it out later, because that's the intent of this statute. So next slide. In fact, the courts are supposed to send out their own notice requiring these hearings and the payment of rent into the registry of the court, but often they don't. And so my recommendation to those of you who represent landlords out there is to very quickly, after the filing of an answer, file a motion to determine rent and set it for hearing, because 9 times out of 10, that is where commercial eviction is going to be resolved. Because if a tenant's not paying you rent for the last 4 or 5 months, they're certainly not going to deposit it into the registry of the court. Next slide. And so finally, after you have obtained your final judgment of eviction, either via the rent determination hearing or via trial or default or some other process, then a final judgment of eviction will be entered and a writ of possession will be issued by the clerk of court. The writ is put in the hands of the sheriff. The sheriff goes out, posts it at the property, and meets your client for the changing of the locks and the turnover of the property. And it's after that writ of possession has been posted and finalized that your commercial eviction is finalized and is clear of bankruptcy court and other concerns that we can talk about later today. Next slide. So in conclusion, there are currently no stays, no moratoriums in effect for commercial evictions in Central Florida. But given the market concerns about the ability to relet premises, there are ample incentives for landlords to work with the majority of their tenants to help resolve these issues. Because, I mean, the bottom line is that in most spaces right now, if you evict your tenant, the market for reletting is soft, to put it mildly. So with that said, I will turn things over to my law partner, Tim Miedona.
Good afternoon, everybody. Thanks for everyone's attendance. As mentioned, I am the co-chair of the Lowndes Commercial Leasing Practice Group. I represent landlords and tenants in primarily retail settings, your restaurants, your cinemas, your performing arts centers, your bars, all these businesses that just thrive in this environment. So I definitely saw a lot of different requests and different possible solutions to this, the COVID pandemic, to work with each other. And so with that, we can go to the next slide. So, starting off, the first thing between the landlord and tenant, before they even enter into discussions, I think it's always a good idea to do a quick confidentiality agreement, just to make sure that maybe what one party's offering doesn't get out to the market so everyone expects the same thing. So that's just a good practice point, something I would recommend. And then secondly, if there's a mortgage on the property, if you're representing the landlord, a lot of times you're going to need your lender's consent before you change the terms to the lease. You're going to want to make sure that you have your lenders sign off on that. That also applies to tenants who have leasehold financing. Next slide, please. Okay, another preliminary concern is if you're dealing with, a lot of times you see this in the restaurant space, the tenants are franchisees of franchisors, and so the franchisor also has approval rights. And so that's another thing that you're going to want to make sure that is cleared before we enter into any lease amendments. And then last is the form of the lease workout. As you'll see on the slide, the highly recommended form is just a lease amendment that deals with the possible solutions. I've seen side letters where the landlord and tenant enter into a side letter agreement. And then the last form, which I don't recommend and no one should recommend, is just a verbal handshake deal that this is how we're going to go forward. So with that, next slide. So the first thing that the big thing with the workout consideration is the rent. That's the issue. The tenant is either shut down or his capacity is diminished, or business just isn't there due to the pandemic. And so primarily the number one thing I've seen in this space has been the rent deferral. And by rent deferral, I mean, what I saw was basically for the months of April and May, landlords were agreeing to not force the tenants to pay the rents for those months, but instead pay those back over time in the future. So normally what I saw was, April and May rent was deferred. The payback of that rent was spread out over 12 months starting January 1, 2021. Rent abatement, this is probably reserved for either the smaller tenant who really couldn't make it otherwise, or maybe an industry that is completely shut down and really can't make ends meet. And rent abatement is just basically the landlord forgiving the rent and nothing else than that. Some tenants and landlords got creative and decided, we're partially open, we can make a little bit of money, so instead of paying you the full rent, we'll pay you a percentage of the rent. And then obviously that could create a deficiency. And then the last point here is the payback of the rent deficiency, which I mentioned before. What I typically saw was payback over 12 months, usually starting either after the free rent period ended, or maybe the first day of the calendar month of the next year. And these are all kind of things that you should consider when you enter into new leases as well. If you want to kind of pre-negotiate pandemic issues, these are things that we can insert into leases, and I've done that on leases going forward as well. Next slide, please. So if you're representing the landlord, there's other considerations that you want to think about for your lease amendment if that's the route we go. Essentially, you're giving the tenant credit by not making them pay rent. And so you can actually ask for some things that you would typically see with a lender. So what I've seen, we've asked for more financial reporting obligations of the tenant. The tenant's, crying wolf, they're not making money. Well, let's make sure that that's the case. Additional security, maybe a personal guarantee or something like that. We've inserted provisions that allow for the landlord to have a better position in a bankruptcy, and that's something that we'll talk about later in the presentation. Maybe we want additional remedies upon a tenant default. Maybe the lease was light on remedies, and now you want to have more of a hammer if they don't live by the newly struck deal that benefits them. And then there's other things that you want to look at in your lease too. The tenant might have a right of first refusal that maybe you want that to go away in consideration of giving them this relief. Maybe there is early termination rights for the tenant you want them to waive. Self-insurance, obviously their credit could be an issue, so now you want them to go ahead and get insurance instead of self-insuring. Who they can assign the lease to, all these other issues are things just to look at in your lease and decide whether that still makes sense going forward. Some other clauses that I'd like to see in a lease amendment if I'm representing a landlord is waiver of force majeure and impossibility defenses, which Ronnie's going to talk about next. Some indemnifications if COVID spreads at the premises and the landlord gets sued, you want the tenant to handle that lawsuit. You want the tenant to comply with all the CDC guidance that's out there. You want the tenant to pursue any business interruption insurance claims they might have. And you also want the tenant just to increase their viability to pursue any governmental COVID-19 relief that's available to them. Next slide, please. So next slide, please. Okay, so if you're representing the tenant, you've got a whole other set of issues that you might want to deal with here. And one is, what happens, the shutdown happened and now there could be another shutdown if we can't get the pandemic under control. So let's go ahead and pre-negotiate what happens in that instance. Maybe you want to have the landlord waive certain remedies due to tenant's failure to comply with the lease. Maybe it's not a default if they can't be open, if there was a, continuous operation, requirement in the lease. So maybe you want the landlord to waive some of their remedies in those instances. If the tenant was in a lease where maybe, this happened at the beginning, I had a couple leases where the landlord owed the tenant tenant improvement allowance, but the tenant couldn't really open and get going. The tenant's going to owe the landlord that, or maybe the landlord hasn't paid it yet. And so those are things you need to kind of button up in this lease amendment. And then finally, in the shopping center context, a lot of times tenants can negotiate a co-tenancy provision, meaning, if you're in a public shopping center, if Publix isn't open, or if 80% of the center isn't open, then I have additional remedies. And so that's another thing to look at if you're the tenant is do you have rights under the lease because of a co-tenancy failure? Next slide, please. I guess that's it for me. So with that, I will turn it over to Ronny Edwards. And obviously, if you have any questions on the lease amendment or lease workout issues, please send us questions at the end and I'll be happy to answer.
All right, thanks, Tim. And also thank all of you for attending this presentation today. I hope you're finding it helpful and will continue to find it helpful. As Tim said, fortunately, we have seen a great amount of cooperation between landlords and tenants over the last 6 months or so when it comes to negotiating how to handle COVID-19 and its effects. Unfortunately, in a few situations, it hasn't been so amicable, and then we get into more of a litigation setting. And so that's what I'm going to discuss, and I'm going to focus, if you want to go to the next slide, Michael, on really 3 of the key doctrines that we're seeing in any litigation at this point, those being force majeure, impossibility of performance, and frustration of purpose. That's not to say that these are the only potential issues for landlords and potential defenses for tenants in lease litigation arising from COVID-19, but these are certainly probably the 3 most popular. So let's start with force majeure. We can go to the next slide. So force majeure generally, I think we all know that the phrase translates to superior force, and that force majeure clauses are clauses that are often buried in the quote unquote standard provisions of a contract or a lease that address what happens when certain types of these superior forces or factors outside the control of the parties to the contract prevent one of the parties from performing or fulfilling its obligations under that contract. And even though these are buried often in the contracts, I think we, even as lawyers, are now coming to realize just how important these provisions are. And particularly in situations like this, where there are things and events that occur that are not contemplated and quite frankly couldn't have been contemplated when a lease was executed. And we need to know, okay, well, what happens? So the first thing to consider is, well, does the force majeure provision apply? And so we need to look at the factors for application. And the first thing to consider is, well, is the clause itself valid? And that's a hurdle that a lot of times folks overlook. They just assume it is. But you have to first check with the law applicable in the lease. Even though we're here in Florida, oftentimes we run into leases that apply out of state law. But in Florida, the biggest legal consideration in terms of validity of a force majeure provision is generally whether the force majeure clause makes the lease illusory, meaning that there is no real obligation on the part of at least one party to the lease. And under this analysis, Florida courts examine whether the force majeure events as they're defined in the lease were either unforeseeable, or if they were foreseeable, whether the events giving rise to the application of the clause were beyond the party's control. And so really what Florida courts are looking to avoid here is essentially a get out of jail free card for one party if an event was foreseeable or predictable or could have been controlled by that party. So then secondly, we need to look at the lease itself, because force majeure provisions are almost entirely contingent upon the language within the lease. This is perhaps not unsurprisingly where most of the uncertainty comes into play. So in going through this analysis, you have to look at the words themselves in the force majeure provision. And in doing that, you really come to the next bullet point here, which is, does a particular event that one side wants and the other side doesn't want to fall under the force majeure provision fall within the definition as that term or that phrase is used in the lease? And again, there really is no one-size-fits-all answer, and we're going to have to consider the specific force majeure provision in the lease we're looking at. So for example, when considering COVID-19, if the force majeure clause uses the word epidemic or pandemic, and believe it or not, I have seen some over the last 6 months that do include these words. But if these types of words are included, then I think there's a very strong argument that yes, the force majeure provision does apply. But what if the word pandemic or epidemic or phrases, other phrases that I've seen, such as national or state health emergency or governmental prohibition or other phrases that might, I think, more easily fit into the COVID-19 situation, what happens when those aren't found in the force majeure clause? Well, then you kind of really have to take a hard look at what is there and see if you can fit COVID into one of those words. And the biggest question that I get from clients is, well, what about this phrase act of God? Because most force majeure provisions use the phrase act of God at some point in the provision. And I tell clients in those situations, I don't think that phrase would pick this up, but I don't know. And certainly I think there's going to be some litigation over that phrase and whether an act of God or COVID-19 would qualify as an act of God. The reason I say I don't think it does is because Black's Law Dictionary defines an act of God as, quote, an overwhelming, unpreventable event caused exclusively by forces of nature, such as earthquake, flood, or tornado. So I think given that definition, it'd be difficult to pigeonhole COVID-19 in as an act of God. But then also when you're looking at the words in the force majeure provision, also look for catch-alls. So for example, some force majeure clauses specifically reference a number of items, be it flood, fires, wars, etc., and then conclude with something along the lines of, or other events outside the control of the parties. Well, I think now you may have your hook if there's a broad catch-all in the force majeure provision. But so assuming the force majeure clause would apply in this instance to COVID-19, then the next question we have to ask ourselves is, did the force majeure event prevent or hinder performance? And again, I think this is another factual intensive inquiry. And in answering this question, Florida courts have noted that the party declaring the force majeure must prove that the force majeure event caused the party's non-performance. So it's on the party seeking to assert the protections under the provision. So, the question then becomes, for example, in COVID-19, but for COVID-19, where the party declaring the force majeure have been able to perform under the contract. And while I think this seems fairly straightforward, I don't think that answer is ultimately going to be as easy or straightforward as some may think. For example, I can see an argument that it was not COVID-19 that caused the performance or the non-performance. It was the governmental orders, reducing capacity or stay-at-home orders as they previously existed. And then so, you get into a debate, well, if epidemic and pandemic, but is used in the force majeure provision, but governmental orders is not, does COVID-19 then apply? So again, I think there are a lot of technicalities that we have to be very cautious about when we're considering the application of this. And then what relief is granted by way of the provision is, if you make it this far, you certainly can't declare force majeure without looking at that. And particularly in leases, and particularly in cases where landlords have the upper hand in terms of negotiating power or bargaining power, one of the biggest examples that I see is that they'll relieve the parties from performance except for the obligation to pay rent. Well, if you got a tenant who's looking to use this to avoid its obligation to pay rent, and you've got an exclusion like that in the provision, then even if the tenant can get through the rest of these hurdles that we've just discussed, the force majeure provision isn't going to do the tenant any good. And then lastly, before we move on, what are the consequences for impermissibly declaring force majeure? Well, an improper declaration of force majeure is likely going to lead to a default in the lease. In the COVID-19 situation, it's typically going to be the tenant saying, because of COVID-19 or governmental orders or whatever the case may be, I'm excused from paying rent. The tenant doesn't pay rent, the landlord disagrees, and if the landlord is ultimately right, the tenant then is in default to the lease for failing to pay rent. So again, declaring force majeure is something that should be done with care and with caution, and certainly with legal consideration and consultation. So we can go to the next slide. While force majeure is perhaps maybe the most glaring thing that we are hearing, and certainly that I think a lot of the articles are picking up on, we certainly got other doctrines that are equally as powerful, I think, if they apply. The first of which is impossibility of performance. And this is a doctrine that is a defense to non-performance that, when applicable, excuses the party from performing its contractual obligations. It's different from force majeure in a lot of respects that we'll discuss, but it can essentially have the same result. So what is required for the impossibility of performance doctrine to apply? Well, what this doctrine requires is a circumstance where, due to no fault of either party, performance under the contract is rendered entirely impossible. And that phrase, entirely impossible, is important, especially, I think, where the contract is a lease. So for example, if a tenant cannot operate on the lease premises because it's not deemed to be a provider of an essential service. Think back to when only essential services were allowed to operate. Does that render performance entirely impossible? Well, I don't know. I think an argument can be made that unless the term is set to expire before the expiration of the orders that prohibited non-essential businesses from operating, then there's a decent argument that performance isn't rendered entirely impossible, because at some point the tenant is going to be able to resume performance under the lease. But regardless, I think when considering this question and the application of this doctrine, you have to start with two things. The impossibility must be as to the entirety of the performance, and again, it must be due to no fault of the party. And so when will it not apply? Well, the lead into that was really the statement that I just made, is it's not going to apply when the lease assigns the risk to one of the parties to the lease. So for example, one thing that I've litigated, and this was pre-COVID, was a lease that placed the burden on the tenant to obtain all necessary permits to conduct the tenant's business on the premises, and then gave the tenant the ability to terminate the lease within 90 days after execution if it was unable to obtain those permits. The 90 days passed, and the tenant neither completed the steps necessary to complete the permitting process, nor terminated the lease, nor sought an extension from the landlord to obtain more time to acquire these permits. And the court found that the tenant assumed the risk in the lease of not being able to secure the permits and was bound by the lease, even though their later efforts to secure those permits failed. Other exceptions where the party seeking to rely on the doctrine could have acted to prevent the event rendering the performance. Again, I don't think that's applicable in a COVID situation, but it is something to keep in mind from the larger perspective. And also where the party seeking to rely on the doctrine knew of the facts at the time the contract was executed, that person can't then take advantage of the doctrine. Again, this is an equitable doctrine that looks to say, look, if you knew of something on the front end, you can't take advantage of it on the back end. Let's go to the next slide. The next slide is the doctrine of frustration of purpose, and it's really similar in that it's going to relieve performance, but the difference here is it doesn't require complete inability to perform. It just requires that the purpose of the lease, as the title suggests, has been frustrated. And of course, like with the prior doctrine, the frustration must be as a result of no fault of either party. Now, I do want to mention here that there are a few Florida opinions that have used the phrase substantial frustration, but a vast majority of the Florida courts have, in fact, acknowledged that there is a requirement of a complete frustration of purpose of the lease. So how is the frustration of purpose doctrine different than the impossibility of performance doctrine? Well, under the frustration doctrine, again, compliance could technically be feasible, but the doctrine is applied when, notwithstanding the fact that the parties can technically apply or comply, the purpose of the contract is entirely frustrated. Kind of similar to the impossibility of performance doctrine, when will the frustration doctrine not apply? It's not going to apply where the risk was foreseeable. One court put it as follows, that the doctrine doesn't apply in situations involving, quote, difficulties which could render or which could reasonably have been foreseen by the promisor at the creation of the contract. So again, as long as the lease was executed pre-COVID, I think someone trying to rely on this doctrine as a result of COVID is probably in the clear. But if you've executed a lease after kind of the outbreak of COVID began, I think you'd have trouble relying on this doctrine for this reason. Again, if one party has the ability to prevent the risk, the frustration doctrine is not going to apply. And again, we look at how does the lease assign risks, and did one party in the lease assume the risk? Because where one party assumes the risk of the frustration or is assigned that risk by virtue of the lease, then the doctrine isn't going to apply. And I think this makes sense. I mean, if the parties have agreed who bears the risk of a particular event, the law should not and have the ability to undo that bargain. So with that, I want to turn it over to my partner, Mike Provenzale, to talk about creditor and lender concerns and to bring this presentation home.
Great. Thank you, Ron. Michael, if you go to the next slide, please. So first, just a bit of a background. I think we've all seen in the media since COVID has happened that there have been an increase of bankruptcy filings. I want to talk to you today both about the impact of bankruptcy on leasing issues and then some concerns when a tenant hasn't filed bankruptcy but is perhaps on the verge of filing bankruptcy and what to think about. By way of background, there are three main types of bankruptcies. There's more than that, but for the purpose of the general understanding, this will cover it. There's Chapter 7, which is the liquidation of the debtor. And that could be an individual person or a married couple or an entity. Secondly, Chapter 11. Chapter 11 is the reorganization chapter. Likewise, could be individuals or business entities. Far more often, it's going to be a business entity. And that's the chapter that you'll mostly hear about in the news. We hear about major corporations that have brand recognition you've heard of filing bankruptcy. That's almost exclusively going to be a Chapter 11. And there's actually a subset of Chapter 11s called Subchapter 5, which was newly created pre-COVID, but has been expanded as a result of COVID to allow more small businesses to use Chapter 11 in a more streamlined, stripped-down version of Chapter 11 that is potentially less expensive and less time-consuming for those businesses. And that's really what we're going to focus on today, because that's really where you're going to see the leasing impacts apply. And then finally, Chapter 13. Chapter 13 is essentially a reorganization of an individual's debts. It's available for individual debtors that have a regular income and want to propose a planned reorganization where they pay off their creditors over time. Can you go to the next slide, please? So the first thing to know about bankruptcy, if you are representing a landlord and you find out a tenant has filed bankruptcy, the first thing to know is the automatic stay. The automatic stay is very simple to understand. There's two words, they mean exactly what they say. Automatic means it applies immediately upon the filing of bankruptcy. The tenant debtor doesn't have to send the landlord a formal notice to say it's filed bankruptcy. The court case doesn't have to be opened. The mail doesn't have to be received by anyone, et cetera, et cetera. Anything you possibly think of, it's automatic. As soon as you are aware that there is a bankruptcy, you're aware of the automatic stay clause. Secondly, the word stay prohibits creditors from taking any further actions. So, as Jamie talked about, normally you start an eviction by sending a demand letter. If there's been a bankruptcy, you can't send that demand letter. If the bankruptcy happens in between sending the demand letter and filing your lawsuit, you can't file your lawsuit. That can be lifted by the bankruptcy court through a motion for stay relief, and there's bases for the court to do that. But the bottom line is you can't take those actions without getting bankruptcy court permission first. And it's important to know that if your client does violate that automatic stay, it's potentially liable for damages. And now it has to be an intentional violation. So again, if you sent a letter an hour after the debtor filed and you didn't know they filed yet, that's not going to be an intentional violation. But you do hear sometimes hear of egregious cases where, notwithstanding that the creditor actually knew of the bankruptcy filing, they went ahead with some collection activity anyway, and that exposes them to damages, both the actual damages suffered by the debtor as a result of that action, and potentially the debtor's attorney's fees and costs in dealing with that and seeking those damages in bankruptcy court. So importantly, if there is a bankruptcy and you know about it, the first thing you should do is stop what you're doing and think about where you need to go. Next slide, please. So in a bankruptcy, there are options for the tenant as to what to do with their lease. They essentially have two options and a period of time to make their choice. The first is they can keep the lease. So if they have a lease in a retail lease, for instance, like Tim was discussing, if this is their best store, they have the sales far and away of any other store they have, they're probably going to keep that lease. So in order to keep that lease, the tenant has to do two things. It has to cure any defaults. So if there were missed months of rent leading up to the bankruptcy, those have to be paid. If there's missed months going in post-bankruptcy, those have to be paid. And they have to provide adequate assurance of future performance. So it's not enough to just say, okay, here's the money I owe you for today, but I don't know whether I'll be able to continue or not. The tenant has to show some possibility that they're going to be able to continue operating and paying the lease. The other option for the tenant is to reject the lease. And this is frankly why you see a lot of bankruptcies of large retailers that have a lot of locations, all which are leased, because bankruptcy provides them a forum to get rid of a lot of their leases that they don't want to keep because they're no longer marketable leases. And so if a tenant decides they want to reject a lease, they first have to deliver possession back to the landlord, which frankly is very helpful for the landlord because it avoids all the eviction steps that Jamie talked about earlier. The landlord doesn't have to file an eviction, they don't have to sort of rid of possession. The tenant has to deliver possession. If the lease is rejected, then landlord is given a claim in the bankruptcy for a portion of what they're owed from the tenant. Jamie mentioned earlier the possibility of filing in your eviction action or separate action a lawsuit for damages for breach of the lease. So those damages are generally available in your bankruptcy claim, but there is a limit to it. You are entitled to any amounts that you owed prior to the bankruptcy. You're entitled to rents that accrue from the beginning of the bankruptcy until the lease is rejected. And then you're entitled to a limited amount of the future lease damages. Ordinarily, you would take the span of the lease, if it's got another 10 years on it, and calculate the amount of rent over that 10 years, reduce it to present value, and that's what you'd be suing on. In your bankruptcy claim, you have a cap on that. That's the point 3 of the slide. The cap is greater than 1 year of lease rent, or 15% of the balance not to exceed 3 years of rent. Importantly, though, as we mentioned earlier, you may have guarantors of the lease, and if those guarantors have not filed bankruptcy, you potentially can still pursue claims against them, and potentially for the full amount of the damages. Next slide, please. So the timing of rejection of leasing, that's a very important protection for the tenants. They don't have to make their decision on day one of the bankruptcy, and often if they were hurried into filing bankruptcy to avoid something that was going to be catastrophic to their business, they've likely been focusing on that and have not had time to assess their full portfolio of leases. So the bankruptcy code provides the tenant with 120 days after the filing to decide whether they want to assume the rejected lease. And again, we're focusing on commercial leases. There's different timelines that apply for residential leases. That timeline can be extended on the request of the debtor for another 90 days, with 210 per day. During COVID, we've seen that's frequently being exercised, and bankruptcy courts are granting that extension essentially anytime they're asked. But there's sort of another side to that coin, in that the tenant has to pay rent for that period of time before they make the determination whether they're going to accept or reject the lease. And so there's some strategy there. Typically, tenants will divide their leases into 3 buckets in their own analysis. One bucket being just their worst leases that there's no way those can be saved, and so they're better off rejecting them sooner rather than later so they can stop having to pay rent. You frequently see those leases rejected for the very beginning of bankruptcy, perhaps even on the first day of the bankruptcy. The second bucket is the leases that could go either way. Perhaps they can renegotiate some of the provisions with their landlord. They might be leases that are worth keeping. They might not be. And then finally, the third bucket are the best of the best, the top couple of stores that they know under no circumstances, unless the whole business is going to fail, are those leases that they never get rid of. And so typically, tenants will use this time period to try and renegotiate those leases in buckets 2 and 3 and see what kind of deal they can get. And so perhaps from reaching lease amendments with their landlords, they can move from some leases from bucket 2 to bucket 3 and keep more. During that same time period, tenants are often also thinking about how they are going to emerge from bankruptcy and whether, in fact, they're going to still be in control of those leases and provide a Chapter 11 plan reorganization, or if they're going to try and sell the business as a going concern. And frequently, we're seeing businesses that have gone into bankruptcy with big lease portfolios typically are exiting bankruptcy by shedding the worst of the worst leases and selling the business to someone else who's going to come in and operate, whether that be either secured creditor or actually potentially a competitor of the business world. And so that person, whoever the buyer is going to be, is going to want to have input on which leases are kept and which leases are rejected. And so usually that process takes some time. And so you see the debtors going through this 120-day, 210-day process to figure out which locations they're ultimately going to keep and which they're ultimately reject. Next slide, please. Outside of bankruptcy. The question is, what do you do as counsel for the landlord when you think you're getting there? As Tim mentioned earlier, oftentimes landlords have mortgage loans on their property that's leased. And those loans have provisions that usually restrict what they can do with leases, and particularly may have notice provisions to notify the lender when leases are being renegotiated. And so the first point here is to communicate with your lender. If the loan documents have specific provisions, you certainly have to comply with those. But even if they don't, it's often better practice to have a communication with the lender up front to say, look, we've heard that this tenant is having financial trouble. We're going to talk to them about reworking the lease. And what are your thoughts on potential structure? And make sure they're on the same page as you are. That way you don't spend time trying to cut a deal with the tenant or the lender wants to. Second, look at the loan documents. The loan documents probably have provisions that are going to be impacted by a tenant or multiple tenants no longer paying rent. They may have debt to income ratios that, if the landlord's not getting rent payments, may be difficult to meet. They have occupancy covenants. As you mentioned, they have requirements that lenders approve lease modifications. Those are things that you want to know about ahead of time so you can plan for it. And then what we hear a lot of times, particularly with smaller businesses that have real estate that they lease, they are in large part, if not wholly, dependent on the lease payments from those tenants to make their mortgage payments. And so, particularly at the outset of COVID, when we saw a lot of tenants stop paying rent, and it was good intention as landlords were, they simply couldn't deal with a situation where they need to make their mortgage payment, but they have no rents coming in. And so what you're going to have to do in those situations is talk to your lender and help them understand where exactly you stand financially and try and match up what's happening with your tenants versus what's happening with your loan obligation. As I think Ronny mentioned, most lenders and landlords have been able to work out deals in these situations, but sometimes it takes a little hardball to make that happen. And I think as the landlord, even if you can't make your loan payment because tenants aren't paying you, a lot of times lenders don't want to step in and file foreclosures right now, whether you take over leases that are in bankruptcy or vacant spaces that they're going to have to try and release. And so you do have some leverage there to try and negotiate. Next slide. And so I think that is it for our presentation, unless anybody has questions. So thank you all for your time today.